Next matter to come before the court this morning is City of Akron versus Berenato. Both sides will have 15 minutes to present oral argument. The appellant may reserve up to 5 minutes for rebuttal. If you let me know when you get started, I'll try to keep you informed if you're reaching into that rebuttal time that you wished to reserve. Please don't use the names of any victims or minors as we are recording this argument, and it will be posted on our website. We have read the briefs and we are ready to proceed when you are.
Thank you, Your Honors. May it please the court, Attorney Angie Killey on behalf of the appellant Bereichy Berenato, and I would like to reserve 5 minutes for rebuttal.
Thank you.
Your Honors, the first issue presented in this case is a question of whether or not the court erred in failing to dismiss this case for failure to properly arraign as a result of my client not be given an appropriate interpreter at every critical stage of the proceedings, specifically at his arraignment and his first pretrial. As a court, I'm sure the court is aware of some of the procedural history here, but it seems to me that in reviewing the transcripts, and first I will say that this transcript is not spectacular. There's a lot of information that appears to be missing, and I think some of that is just because of the fast and fluid nature of how the municipal court has to function. However, when this defendant in particular appeared for his arraignment, the case law is pretty clear in the state of Ohio that he does have a right to an interpreter and to understand every stage of the proceedings that are taking place against him. In this instance, it did appear as though there was an interpreter present at the arraignment in Akron Municipal Court, but there was no paperwork filed for the request of an interpreter, no information available as to whether that individual was sworn in, no information as to whether or not that person was in compliance with the rules of superintendence and was certified by the Ohio Supreme Court. In fact, we don't even know what language that individual was speaking because it wasn't put on the record or anywhere in the file. There was absolutely no dialogue between the court and the defendant, with the exception of one question about a job, but there was no response from the defendant. So essentially, on a review of the record, not only did the court fail to comply with the criminal rules and go through and read this particular defendant his rights, there is nothing that indicates that the court provided him with someone who could speak a language that he understood or had any idea of the nature of the charge or any of these proceedings that were being brought against him. And he remained in jail for the entire time. I realize in the grand scheme of things, we're only talking about a matter of days because we're talking about a misdemeanor, but we're still talking about an individual who we have absolutely no information to verify that he was aware of what was taking place or what was going on, and sitting in jail until he comes back for his first pretrial. And when he comes back for his first pretrial almost a week later, it just happened that it was the same judge. The same judge who did the arraignment clearly was aware that this particular defendant didn't speak English, or at least not well enough to be able to communicate. And during that time frame, there was no interpreter present again, which there should have been. The rule is pretty clear that the court is required to provide one in order for someone to understand what's happening. There was no interpreter present. They hadn't even ascertained what language, if any, that he spoke. And at the close of that hearing, when it was set over, the court left him in jail. He still didn't have any indication as to whether he knew what was going on. And once they got into the question of what language he spoke, what the court did was put the burden on the defense attorney to find out what language this gentleman speaks and to find an interpreter. It's the court's responsibility to find and provide an appropriate interpreter for anybody who doesn't speak English. That didn't happen in this case. By the time it came back on July 20th on the same proceedings, there was an interpreter present. That interpreter had been procured by the defense attorney. You have to forgive me, I believe his language is Chuckese. I'm not 100% sure if I'm pronouncing that correct because it's one I've never seen before. They did have an interpreter present at that time. The court did, we kind of flow into the second assignment of error at this point in time because the case resolved. And in addition to the interpretation issues, the court really didn't comply with Criminal Rule 11b2 during the plea. And I think that the fact that the defendant is limited in English made it even more egregious because there's no indication, once again, really that he understood what was happening. The defense attorney did make an oral motion to dismiss for failure to arraign. The court blanketly denied that. All the state argued was that they were aware that there was a delay in getting him an interpreter. The court said that it was an insignificant amount of time and that it had not really affected him. However, I would argue that due process requires that he understand from day one, and that it really should have been dismissed.
Counsel, was it simply an oral motion to dismiss, or was it?
It was an oral motion to dismiss. In a review of the record, the statements that were made in transcript was that it was being filed, but I did go over to municipal court and check to verify because there was nothing sent over here that indicated a written motion had been filed. Apparently it had been prepared, but it was never actually filed. So it was in fact an oral motion to dismiss. However, it would be our position that the court should treat it the same way since the court did entertain it as well as rule on it in open court.
Thank you.
When we get to the criminal rule 11 issue, our position is that the court violated the defendant's rights and that his plea of no contest was in fact void. Once again, once we get to this point, the court was under an obligation. It's not as strict at the misdemeanor level as it is at the felony level. They don't have to be advised of quite so many issues. However, they do have to make sure that the individual understands what they are pleading guilty to, potential penalties, waiver of certain rights. And in this instance, the only thing that the court really went over in detail with the defendant was a little bit about what a no contest plea went and a little bit about how it could affect his immigration status. Outside of that, the long and short of it is that the court never actually even took a plea directly from the defendant. I did provide some of the direct dialogue that I'm referring to in my brief for the court to be able to reference, but essentially just asked how he pled. He was about to. They interrupted, the defense attorney did. The defense attorney said that he would be entering a plea of no contest. The court never even asked him if that's what he pled. There was no direct dialogue between the defendant and the court. Again, there was an interpreter present who I guess everybody assumed was appropriate since he had been approved by the defense attorney. He was sworn in, but this individual once again did not state any of their qualifications, whether or not they were in compliance with the rules of superintendent from the Ohio Supreme Court. It was really very informal and honestly kind of a confusing transcript, even for someone in my position to be able to read. And I think that when we're talking about something as serious as this, although it's a low-level offense, and the reality of the situation is that this gentleman served most of the time that he could possibly serve for a crime like this, of disorderly conduct, the simple truth of the matter is that we have to ensure that people, especially people who have language issues as well as potential for some sort of deportation or issues with immigration as a result of any type of criminal conviction, really understand what their rights are when they're standing in a courtroom and have those rights waived effectively, accurately, and very clearly on the record, and that is not what took place.
Counsel, let me ask you, I know you're arguing that the plea hearing also was infirm, that it wasn't constitutional as well, that his rights weren't protected by an interpreter requirement as well as Rule 11. But let's just say that the Rule 11 was sufficient and the interpreter was sufficient. Would you still say the fact that his arraignment and his original pretrial, that he didn't have, a certified interpreter or an adequate interpretation, that would be prejudicial enough in order to invalidate everything?
Yes.
Okay, and why would that be? Because I'm not sure case law provides that.
And I'm not going to pretend like I can point to case law that says that that's the case, but I guess I'm looking at it as a global situation and a public policy perspective, because, perhaps not for my client in particular is it necessarily going to make a substantial change to how the thing carries out, no. But from a more public policy perspective, affirming his conviction and saying that it's like harmless for them to have multiple hearings while sitting in jail and not understanding the nature of the proceedings or being able to communicate with an attorney for all these days, to me, opens the door to allowing a violation of constitutional rights for any person. who has limited language skills that comes before the Akron Municipal Court. And I don't think that's something that we can allow to continue as a practice or a policy in any court in this country. And if there are no other questions right now, I will rest.
Good morning, Your Honors, and may it please the court, I'm Kirsten Smith for the state of Ohio, city of Akron. Initially, I'd like to address the interpreter issue. I think it's kind of the crux of this whole case and kind of permeates through both assignments of error before you today. For the first time on appeal, appellant is asserting that the trial court failed to secure an appropriate interpreter. At no time across the 3 separate dates in which the trial court met to consider this matter did Mr. Berenato's counsel indicate that the interpreter was insufficient. Mr. Berenato himself never did anything to indicate that he didn't understand.
Counsel, so the city argues that, going back to the oral motion to dismiss and the arraignment process, that since Mr. Berenato didn't raise any issues at that point, that now isn't the time to bring those forward. But how could a defendant who couldn't understand the proceedings know to raise those kinds of issues?
He may not have known to raise those kinds of issues. However, his counsel had presumably spoken with him, had some sort of dialogue with him. And
Does the record show that?
The record does not show that. However, Mr. Berenato was represented by counsel throughout this entire matter, and at no point did his counsel object to the interpreter that was evidently in use at the arraignment or at the second pretrial when the plea was entered.
We don't even know who his counsel was in the initial arraignment, right?
Correct, the record is
He
silent.
wasn't, at that point, he didn't have a public defender that was actually assigned to him, I should say.
Correct, the record indicates there was counsel, however, we don't have who that counsel was.
And I'm sorry. No, you go ahead.
But counsel, we do know that the interpreter at the arraignment did not speak the language that Mr. Berenato spoke, correct?
That's actually also not clear from the record. It's evident there was some confusion with which language he spoke. However, during that arraignment, there's no indication what language that first interpreter spoke, I believe. It wasn't until the court pressed the issue that they discovered there may be an issue with the interpreter. And they did actually have dialogue during that first pretrial where the court and Mr. Berenato's counsel went through language line trying to determine which language this individual spoke.
But ultimately, didn't they end the proceedings with an understanding that they needed to find an interpreter?
Correct. So the language line does not immediately offer chukis, I believe it's pronounced, interpreters. So the trial court indicated that that had to be scheduled and that Mr. Berenato's counsel would schedule that interpreter at a later date. Now, at the second pretrial, we did have an interpreter present who was sworn in. However, it's not indicated whether that's from, the Supreme Court services or Mr. Berenato found someone else to interpret for him.
Can I take you back, counsel, if I might, to the arraignment, the initial appearance there? The city's brief argues that defects in the arraignment process constitute harmless error, correct?
Correct.
Okay. So is it harmless error to fail to advise the defendant of his right to a trial by jury, or not to make self-incriminating statements, or right to counsel?
In this case, I believe it was harmless error. The court entered a technical not guilty plea on Mr. Berenato's behalf. He made no incriminating statements against him. And at the second pretrial, any of those errors that did occur, I would argue, were cured when the court did have a dialogue with Mr. Berenato. The court did ask him if he understood he was waiving his right to a trial and entering a plea of no contest. So Mr. Berenato, I believe, simply was not prejudiced by any errors that did occur during that first arraignment. And this court has held when an individual doesn't receive a copy of a complaint, or when the court doesn't read the complaint against him and he makes no incriminating statements, that it is harmless error. And I'd just like to briefly go over the plea issue that we discussed as well.
Counsel, before we move on to the actual plea issue, I guess I'm still confused in regard to the interpreter that was there during the plea hearing. Did the court inquire of the interpreter in any shape, manner, or form as to what her qualifications, or his qualifications were?
The court did not do that, however, given that it was selected by defense counsel, I think it's reasonable to assume that this individual would speak this language and be competent to interpret. The court also did administer the interpreter oath to him. That verbatim is not on the record, as opposing counsel indicated the transcript in this case is not great. But
How can you assign the responsibility that the court has inherently to obtain an interpreter to defense counsel?
The court just asked them to schedule the interpreter because it's not via the language, and the court had no means to do that, select the interpreter and make sure it's a date when opposing counsel was available. Additionally, as I stated before, we have no objection on the record, so we're really in plain error realm on appeal. And opposing counsel appellant hasn't asserted a plain error argument, and this court has long held that it won't develop one on their behalf.
We won't develop one on their behalf unless we see one. Do you think the court can just go ahead and ignore plain error if it's egregious?
Well, even if the appellant had made a plain error argument, I don't think this rises to the level of plain error. This court has held that the rules of superintendents don't operate to create a substantive right. And the rules regarding interpreters and the court's selection of interpreters are in Rule 88 of the rules of superintendents. So,
But they're also statutory, and there's case law that says that they're constitutional due process rights.
well, so I would argue, the superintendents, we don't have that, and any other issues were cleared at that second pretrial when Mr. Berenato, there was the dialogue between the court, the interpreter, and Mr. Berenato. They had a conversation in which he indicated he understood the proceedings against him. So I would argue that this court overruled first assignment of error regarding the interpreter. Now regarding the plea, the second assignment of error states there was a complete failure to comply with Criminal Rule 11. Based on the record before this court, that's just simply not accurate. The record demonstrates that Mr. Berenato was charged with a petty offense, and under Criminal Rule 11, the court's only obligation was to inform him of the effect of the plea. And he did. Mr. Berenato, through his interpreter, indicated that he understood that, and the court correctly accepted his plea of no contest.
I understand it was modified and obviously is a disorderly conduct, but he was originally charged with the domestic violence, right?
Correct, and then pursuant to an agreed upon plea, they amended the charges to disorderly conduct. So unless there are any further questions, I would ask this court to overrule Mr. Berenato's assignments of error and affirm the decision of the trial court.
Thank you, counsel.
I'll waive my 5 minutes and rest on my brief at this time.
Thank you both for your presentation today. The court will take the matter under advisement. We will issue a written decision which will be mailed to all parties to this appeal as well as posted on the Ohio Supreme Court website.